Welcome, everyone. Thank you all for joining us this morning for our webinar on how to grow your business value and bottom line using two overlooked tools, R&D tax credits, and intellectual property asset. I'll spend about a minute talking about the firm, and we'll talk about our guests, and then we'll get started. So we have Bob Doyle on the line, and Bob and I are the partners in Imperial Advisory, outsourced CFOs, where we provide CFO services for all sorts of businesses. Mid-sized businesses that don't have a CFO. We do advisory work for larger businesses that do have CFOs. And we basically become one of the CEO's best friends and help them grow and scale. We were just on an interesting call with the CEO who's looking to do just that. He is a client, and hopefully we're going to be working with him for a long time as he grows. Anyway, we also have Ariel on the line. Ariel takes care of helps us with a lot of things, gets things done, and she was instrumental in putting this webinar together. All right. The presentation today, as I mentioned the title, it's about R&D tax credits and IP assets. We're very excited to have Yair and George, who are going to tell us how growing companies, or probably all sorts of companies, can get more money today. That's probably more on the Yair end, and George probably have to spend some money on building your IP asset portfolio, but we're going to learn how that can help your business sell for more money later, help protect you so that you can run your business, because if somebody steals all your good ideas, then you lose your moat. Anyway, without further ado, we're so pleased to have you both, and take it away.
Thank you so much, Gershon. So I just want to make sure that everyone can hear me okay. Can everyone hear me well? Gershon, can you confirm? Or Ariel?
Yes, I can hear you.
Wonderful. Okay, great. So Gershon, thank you so much for inviting me and for setting this up. Like Gershon mentioned, I'm a CPA and tax partner at Anshin, Block & Anshin, a middle market tax accounting firm in the tri-state area, where I specialize in R&D tax credits. The topic of R&D tax credits, one could really spend 40 hours. It could be a full semester university course or law school LLM course to discuss R&D tax credits. We're going to do all of that in about 10 minutes or so. So clearly this is R&D tax credits at 100,000 feet. With that, I am always open and available as a resource to anyone who would like to learn more about the topic. So with that, next slide, please, Ariel. We'll go a little bit into the overview and the history of the credit, opportunities, the four-part tests, which is really the four commandments of the R&D tax credit, the engine of the credit, some calculation drivers, what's going to make up your credit calc, and then documentation issues. Next slide. So like always like saying is, the research credit has always been very widely supported and has enjoyed strong bipartisan support from its inception in 1981. It came about under the Reagan administration and was made permanent under the Obama administration. So there you go. And I think in these times, I think showing unity and coming together on stuff is really important. So the research credit has certainly served as an area where everyone can agree. I always say it's a little bit like baseball, apple pie, and Thanksgiving. Everyone loves the R&D tax credit, and where there's disagreement or difficulty is on figuring out how to go about paying for the R&D tax credit, which comes to around about $13 billion a year. It was made permanent in the PATH Act of 15, kept in the Jobs Act of 17, and more companies are moving towards, not sure this bullet point should be there, but it's a very important bullet point. So we'll come in and we'll do studies, and then companies will get all excited, and CEOs and CFOs will say to me, okay, how do we make next year not as much of a forensic exercise? What mechanisms and tools can you put in place to better capture these credits going forward? Credits are more valuable than deductions, as the financial folks on the call might know. And the R&D tax credit comes on top of your deduction. So it's actually a double dip. In recent years, there's an addition that allows you to use this against payroll tax, employer portion for early stage companies and startups. Next slide. Opportunities and benefits. It really is the most powerful way for a company to lower its effective tax rate. It's much better than deduction. It's dollar for dollar reduction of tax liability. It's available at the federal level, but it's also available at the state levels. There are 30 plus states that have R&D tax credit. That number changes anywhere from 32 to 37. The states are constantly changing their R&D tax credit regimes. But it's a great way. So you can imagine, you can envision for a company that's spending money on R&D, and we're going to get to what is R&D in just a couple of minutes. You know, you're getting your deduction, your regular deduction that your CPA is taking for your R&D activities. Then on top of that, you're getting a federal R&D credit, right? Dollar for dollar reduction of tax liability. And then if you're in the right states, you're getting a state R&D credit. So certainly a great incentive, I would argue. A great way to refuel a company's R&D tax credit cycle and infuse more money in development. You can certainly envision two companies, one taking advantage of this, the other not. The one that is going to be way ahead because they're getting some more money back into the system to refuel and regrow and catalyze their R&D efforts. Next slide. I love this slide. It's an oldie but goodie. Slide's probably about a decade old, but it drives home two very important points. Number one is this is not a deduction, right? So I've done it, created a life, and more importantly, I've created a tax deduction. So as we just mentioned, this is not a tax deduction. This is a credit that comes on top of your tax deduction. Secondly, you see this mad scientist here creating life in this dummy. That's not the bar, that's not the threshold, and we're going to get into that in a couple of minutes. That is required by the tax code. What's required here is pushing the envelope vis-a-vis your capabilities in the prior year, not creating something that's new to the world or new to the industry, but just new to your company. Next slide. All right, so as you can tell by now, I love slides that look pretty simple and straightforward and that have a lot of pictures in them. This is another slide that I'm a big fan of, although 2020, I have to tell you, really took the slide and put it in a blender, and we could talk about that later, really started mishmashing the lines between product and process. But essentially, there are four buckets that of activity that can qualify. New product development, right? So I'm Apple or I'm Merck or Pfizer developing a new drug or a new iPhone. That's pretty clear, straightforward. New process development, if I'm improving upon a process, reducing steps, increasing a new manufacturing production process, increasing the yield, reducing the waste, that's a new process development. We can understand that. And then incremental product and process development, and to really understand what those two items on the right mean, those would probably need their own hour-long call, because what does the word incremental mean in terms of the tax code? Let me just share with you, based on discussions with IRS agents over the past 15 years, I would say that that word, means non-trivial, not easy to accomplish, right? If I'm Brooks Brothers and I make a suit in the color blue, and then the next year I make that same suit in the color brown, that is not an incremental product improvement. But if I made an outfit in cotton and I want to make it in spandex, or I'm in spandex and I want to make it in cotton, or I want a combination of cotton and wool, that could be more challenging. That could be an incremental product improvement in the fashion industry. And you'll see in a minute, this really applies to almost all industries. The note on the bottom is important. New or incremental to the company, not to the industry or the world. Keep that in mind. If there's one or two takeaways you take away from today, that's an important takeaway. New or incremental to your company, not to the industry and not to the world. That's the bar that has to be satisfied. Okay, next slide, please. So remember, before I said that 2020 kind of really started highlighting the mishmashing of product and process. Well, that's been going on for several years, but 2020 really did a good job putting that in the blender. So companies that had never made PPE before now are starting to make PPE. That's new product and process development, right? What we're finding in more of our manufacturing clients, and I'll say I love manufacturing companies because many times this is completely missed in those environments, because people say, oh, we're just making product. We're making the product we always make. Not so much anymore. Not so much, I'd say, in the past 5 to 7 years, it's really changed. We see a lot of robotic process automation, cloud computing, artificial intelligence, data analytics, cybersecurity, supply chain logistics, really being ingrained and enmeshed inside the manufacturing world, really changing manufacturing companies. Today, when I walk into a manufacturing company, it's almost like I need to just ask them, okay, where are your IT guys? Where are you hiding, your IT people? And I know they have them somewhere. So that's another area where process and product are starting to intertwine. Next slide. Okay, as I promised, these are the 4 commandments of the R&D tax credit, the engine room, so to speak. What has to get satisfied? So if you remember back to high school science, maybe even middle school science, probably high school, this is what we would call the scientific method in a tax version. You need to be improving upon the functionality, performance, reliability, or quality of a product or a process. So I got off a call yesterday, and the CEO said to me, well, I have function, but I don't have performance. You just need one to satisfy one of those 4 bullets, okay? So in all these 4 tests, you have to satisfy all the tests, but only one of the bullets. Technical uncertainty. There has to be some kind of technical uncertainty at the outset. So we are not sure about how to achieve our goal. Otherwise, it's not R&D. Technical in nature. This is really to exclude the social sciences. So engineering, architecture, civil engineering, structural engineering, mechanical engineering, biology, physics, chemistry, computer science, mathematics, all fall in there. And a POE. You need to have a process of experimentation where you're evaluating alternatives, testing hypotheses, and so on. Okay? So these have to be satisfied in order for us to qualify for the R&D tax credit. Now, we can look at these as a subcomponent, as a part of a project. We don't have to look at a project in its entirety. We can look at a subcomponent and qualify a part of a project, of an overall project. Next slide. So what is the timeline that we're talking about? So anything from ideation through commercialization. Ideation is a consultative made-up word. I heard it for the first time when I was working in management consulting 20 years ago. They used the word ideation. So I adopted it. And I would say anything from the point of ideation through commercialization, we're in a room brainstorming about a new product, all the way to now we know how to make the product and we're making 100,000 units. Now, what happens when an issue happens after product is released to market? So for example, in the auto industry, there are recalls all the time. When you have a recall and there's an issue and we have to figure out how to go about addressing the issue, that would also qualify for the R&D tax credit. That is also considered to be R&D. Things like Six Sigma, lean manufacturing, TQM, just in time, automatic automation, robotics, RPA, and so on. So there's a wide variety of things that can go wrong. And when we have to figure out how and why they went wrong and how we're going to go about fixing them, we're back in the R&D phase of things. Next slide. This is what qualifies. So, okay, so we've spoken about activities and projects. How does this translate to dollars, right? We care about dollars. So direct R&D, anyone doing the science, the engineering, and so on. Supervision of R&D, CEOs, CFOs, to the extent that they are technical in nature, strategists, department heads, plant managers, and then support, QA, QC, testing, and so on can all qualify. So people generally tend to think, oh, it's my scientists and my engineers. Correct, but it's actually 1 degree above and 1 degree below those individuals as well. So we're casting a much more broader net of potential dollars that we can include. And then in manufacturing companies, we look at supplies, samples, prototypes, waste, spoilage, and so on, and then outside vendors that we might use in the R&D process. Next slide. So what is excluded, right? It sounds like, wow, there's a lot of stuff that we could include in an R&D credit. What's excluded is work outside the United States. Recall, this is a US incentive. The government wants you to stay in the United States and do R&D in the US. So anything outside the US would be excluded. Social sciences would be excluded, surveys, so on. Style, taste, cosmetics, excluded. Testing, quality control, routine. The key there is the word routine. Routine quality control would be excluded. So testing something for the first time, we could still include. And then funded research. So Department of Energy, Department of Defense, NIH grants, PPP loans, if they were forgiven, we weren't sure for a long time. I can now tell you, you could rest assured, PPP loans do not interfere with your R&D tax credit. But there was a lot of concern with a lot of my clients that their forgiven PPP loans might interfere with their 2020 R&D tax credits. That is not the case. Those expenses are deductible and it does not affect your research credit claim. Next slide. Documentation. So we get to the point, I've convinced a new prospect, a new client, the client that they want to go ahead, but they say, hey, listen, Yair, we don't have any of the backup you need. And this gets back to a point on the earlier slide. We can help you build up this documentation going forward in a way that we know the IRS is looking for it. And it could take a variety of different formats: project reports, emails, lab reports, testing protocols, Excel spreadsheets, and so on. So it could really take a wide range of formats, and we can help our clients and our prospects build this contemporaneous documentation going forward. And next slide, I think that might be it. Yep, just my contact info, if anyone has any questions. Okay. Can you,
Alrighty.
Okay. Was the connection okay? I felt like I was getting cut out. Okay, super.
I heard you.
Okay, great.
All right, Yair, thank you very much. I think we're gonna save questions for the end to make sure we've got time for everything, and then we already have one in the chat, and I think I've got one, and we'll see what everyone else has. Thank you very much, Yair. And
yeah, thank you, Gershon.
Absolutely. And George,
sure.
take it away. Looking forward.
Hi, everyone. Good morning. Thanks for joining us. I'll continue on the topic of this morning's presentation on intellectual property assets and how you can use them to grow your business's volume and bottom line. Next slide. So what is intellectual property? Unlike real property, intellectual property is a general term we use for categories of rights and intangible creations of the mind. The four pillars of intellectual property that we usually refer to are patents, trademarks, copyrights, and trade secrets. Next slide. So first I'll go through each one of these intellectual property pillars, and then I'll go into how we can use them to increase our business's value. So copyrights is a form of intellectual property that protects original works of authorship, whether it could be literary works, dramatic, musical, artistic works. It could be recorded in a medium such as a CD, or it could be online. Anything that was created by someone at some point is eligible for copyright protection. And generally, the term of a copyright is the author's life plus 70 years, and that's by a US federal statute. And if it's a work for hire, if you hire somebody to create something for your business, whether it's a software or an artistic production, it's 95 years from the date of first publication or 120 years from the date that it was created. Next slide. Trademarks. So trademarks help a company because they protect your brands, logos. It's a name recognition. There's federal trademark registration and also state registrations. Each of the states allows you to register your trademarks and logos, but federal registration is usually what you want to have. And trademark rights allow you to stop other people from using your trademark to sell goods or services similar to yours. So, and they also protect consumers because consumer knows the source of the goods or services they're buying. And these are some of the popular, some famous trademarks. And on the upper left there, you'll see the Tiffany box. So color can be trademarked, as well as sounds, smells. anything that identifies the source of the goods, and you can prove that to the US Patent and Trademark Office, you'll get a trademark registration. Next slide. So trade secrets. Trade secrets, unlike copyrights, trademarks, and patents, where you actually have to do something, you have to apply for them. A trade secret is something you don't have to apply for, but you have to take certain actions to keep something a trade secret. So by definition, they're confidential business information that provides a competitive advantage. It could give you economic value, it's not generally known, and you have to, like I said, use reasonable efforts to maintain its secrecy. If you don't use reasonable efforts and the secret gets out there, there's nothing you can do about it. But if somebody steals your trade secrets, let's say it's a disgruntled employee, and they take your secrets and go to another company or sell them, there is a federal statute passed on May 11, 2016 called the Defend Trade Secrets Act. And you can actually now sue in federal court when your trade secrets have been misappropriated. So this act made trade secrets even more important. Previously, if your trade secrets were stolen, you can only sue in state court for misappropriation of trade secrets or unfair business practices. It didn't have as much of a bite as it does now going to federal court. And as long as you keep it a secret, it's your company's trade secret. If it's reverse engineered, if it's independently discovered or publicly disclosed, that's the end of the trade secret. And some reasonable efforts you can use to maintain a trade secret is basically only tell employees who have a right to know, make sure employees understand those are trade secrets, don't leave things lying around where they're in public view. Those are things you can do. Things should be under password protection. Let's say it's a customer list, or if it's your processes that you've developed over many years, all that should be kept under lock and key. Next slide. And then there's patents. There's the most common patent is the utility patent. It protects processes, compositions of matter, articles of manufacture, and machines. And what does a patent do? A patent is generally a contract between you and the federal government. If you disclose what you created, then the government will give you the right to exclude others from making, using, importing, offering for sale, or selling your invention in the US. And that's usually a term of 20 years from the date you file your US patent application. It doesn't give you the right to do anything other than exclude others from making your invention. And that's important to understand, because somebody else may have a broader patent, like your patent may be an improvement of an existing product. So the other person may have the broader patent, and you have a patent that's more narrow in scope. But you then cannot bring your product to market. Obviously, you'll be infringing the broader patent, but you can exclude other people from making or using your improvement. Next slide. And now I'll talk about how to use your intellectual property assets to grow your business's value, some of the things you can do and be aware of. Next slide. The first thing you should consider is, if you're a technology company in particular, is evaluate the breadth and scope of your patent portfolio. Perhaps perform a valuation. It's good to know, just like you know what your real estate assets are, what your inventory assets are, all your assets that you can actually touch and feel, you should also know what your intellectual property assets are. And if you are developing products or technologies, you should know what is the breadth and scope of those patents. And if you want to take it a step further, perform a valuation, understand the value of that patent portfolio. It's very important in case, let's say down the road, you want to sell or you want to use it as collateral, you know that the value of your patent portfolio. Another thing to take into consideration is, do your patents or patent pending applications cover your core technology and the products you are manufacturing? You may have a decent sized patent portfolio, but you may have missed the boat when it comes to protecting your core technology and the products you're actually bringing to market. For example, you may have been in business for 50 years and you obtained a patent 10 years ago on a product that was hot, it was selling, and now that product is no longer being made, or it's made in less quantity, and you're developing some other products. You should go back and reevaluate your portfolio all the time and determine if your patent portfolio is keeping up with the products you're creating, you're manufacturing, including your core technology. For example, if your core technology is making an electric motor and your patents are covering one component of that electric motor, but not completely covering the entire motor, somebody else can change that component, maybe design around that component, and still make something similar to your electric motor. So your core technology should, as best as possible, be protected by your patent portfolio. And then you should also consider who are your IP competitors. Generally, those could be somebody who's not in the same industry as you, but maybe looking at your industry, and maybe they are developing or amassing an IP portfolio to come into your industry. And what we do is we do patent landscape studies. We want to know, and it's good for the business owner to know, who is getting patents in your industry. Are there somebody who's looking to come into your industry and be a disruptor? Is it a competitor that you know about? What are their intellectual property portfolio? What does it look like? What are they focusing on? Perhaps they're coming into your territory, or perhaps they're pivoting in a different direction and creating technologies that may disrupt you down the road. So you have to be aware of what your competitor is doing in the IP world. Next paragraph, excuse me, page. Was there a freedom to operate analysis performed on your core technology? That's very important, because you may think that you have the best product in the world and you're going to come out into the market with it, only to find out that somebody else has it, like I said earlier, a broader patent, and then you don't have the freedom to operate your technology. You may find yourself in a lawsuit. So it's good to always know whether there's broader patents out there, how long of a life is left on those patents, and perhaps if you wait a couple of years before you release your technology to have those patents expire, you may be in a better footing than come out early only to find yourself being infringing somebody else's patent portfolio. So freedom to operate analysis basically means, yes, you have a patent portfolio because you developed something unique and something new, but somebody maybe a few years ago had that idea as well, and they have the broader patent portfolio in your technology. So you may want to identify those patents, see if there's a way to design around them. You don't want to find yourself in a lawsuit when you can have only done some minor changes and been outside their patent scope. So that's important to make sure you do that. And if you're a startup and you're going out for investors, one thing they'll ask is, did you do a freedom to operate analysis? They're not that concerned that you may have patents as much as whether you are able to sell your products and bring your technology to market. So your business value is definitely worth more if you can say, yes, I did a freedom to operate analysis and I can bring my products to market. Another thing to be aware of in doing a freedom to operate analysis is courts look at that as you did your due diligence. So if you do find yourself in court because, let's say, you infringed somebody else's technology, the fact that you did a freedom to operate analysis and your attorney advised you that you're good to go, and you relied on that legal opinion, the court will look at that more favorably than if you didn't do a freedom to operate analysis and you just went into the market blindly and infringing somebody else's intellectual property. The next thing to consider when maybe you're purchasing a company or a business or even your own company, are there any threatened or pending IP litigation against your company? If you receive a cease and desist letter, treat it seriously. Have an attorney look at it, determine whether the patent they're accusing you of infringing is valid, whether there's anything that you can claim, perhaps that patent is invalid. An attorney will do an invalidity analysis to find out if that patent actually that you are being threatened about is a valid patent. Perhaps that patent
Looks like we lost George.
Can you hear me?
Yeah,
Okay,
you
sorry about
froze
that.
for a minute.
My connection dropped. Okay, sorry. So you have to understand whether there's any threat or pending IP litigation. Like I said, if you get a cease and desist letter, definitely take it seriously. I've have clients come back to me several years later after they were sued, saying, I got this letter, I didn't think much of it, and now they're in a lawsuit. And it could have been something that could have been easily handled the first time around, perhaps with a non-infringement opinion, and now you find yourself being in court, being sued. So take those letters seriously. Who owns the intellectual property? Is there a security interest? So the value of your intellectual property is greater if you, the company owner, business owner, owns the intellectual property. And what do I mean by that? So you may have engineers developing products, developing processes, and then they leave your company. If they never assigned that intellectual property to your company, yes, you can rely on the fact that you paid them, they were under an obligation to assign, but they didn't. But it definitely puts a cloud over the ownership of your intellectual property if you don't have assignments, legal documents saying that the inventor assigned his rights to your company. It's easy to show that you're the owner if it's an engineer, let's say, who did not assign, because they were hired to invent for your company. That was their job description. And most likely they had a contract that says anything they create will be assigned to the business owner. But where there may be a problem is if you, let's say, run a marketing agency and somebody in your group develops a software product. They weren't hired to develop a software product. They were hired to maybe be a marketing professional. And now they tinkered, they develop a software product. There could be an argument made that they own that software product because they weren't hired to innovate. So if anybody in your team is coming up with the new ideas, products, make sure everybody across the board understands or signs a legal document that anything they create belongs to the company and they will assign it to the company. And if they are an inventor, let's say software may be a copyright, but if they invent a new process or a new product, they will assign that product or patent to that product to your company. And then whether there's a security interest. That comes in, for example, if you have a patent portfolio, you need money, perhaps you have a trademark that's worth money, and you can go to a bank or a loan officer and can everybody hear me? Sorry about that. My internet keeps dropping today. It's the first. It just opened the door, so hopefully they'll be able to get a good signal. So is there a security interest? Whether a bank or somebody else has a collateral interest on your intellectual property. So if they do, obviously your intellectual property is worth less than if it's owned outright. And another thing to consider is, for respect to trademarks, have your logos and brand names, trademarks been registered in the US and worldwide, right? Your trademark is very important. It's worth probably more sometimes than anything in your IP portfolio because it lasts forever. Similar to a copyright, but it's more stronger because it's your market identity. So your trademark, for example, as long as you use it, it's definitely live, and you can use it to identify your name, your company throughout the world, and it creates value. Next slide, please. Another thing to consider about your names and trademarks, any prior uses of your brand name and trademark. For example, you may have a trademark, it's not registered, but there may be somebody out there who had used your trademark, or is currently using your trademark, and he can predate your use. So obviously that trademark will be worth less than if you're the first user in that particular goods and services of your company, and nobody else has used it before, and you also have a trademark registration. Obviously, trademark registration, a federal trademark registration, gives value to a company. And sometimes I find that trademarks are being used in a company forever. A company may have been founded by somebody's father, now the kids run it, and for 50 years, the trademark was never registered. But when you go out to the market, people know you because they know your trademark. Getting a federal registration should not be that difficult because you've been using it for so long of a time, and it automatically gives you value. It becomes an asset that now you have a federal registration. Very quick way to create value. Register your trademarks, domain names, logos, and so forth. Any IP assets that can be sold, licensed, or disposed of. So how to grow your business value. Sometimes some IP assets are good to own and have them, but sometimes you may find that you're no longer making a particular product that you've got a patent on or have a trademark for, and somebody else may be interested in that product. So maybe sell your IP assets, create value, make your liabilities into assets, maybe license those IP assets, or dispose of them, meaning you're paying patent maintenance fees every 3.5 years for patents that you're not using. Perhaps you should reevaluate your patent portfolio. Maybe there's trademarks that you're paying for every 10 years that you're no longer using. Maybe cut those IP assets from your portfolio. And then another thing to consider is the culture of your company in protecting its IP. Do your engineers come to you when they come up with new ideas? Is there a culture of protecting your innovations? Or is your culture more business as usual? There's nobody looking at what's being created. Nobody's talking with the patent attorneys. Nobody's talking with the CTO. There's no culture of innovation and protecting your intellectual property. That's very important. Sometimes you find that a company, when you do some due diligence, let's say you're looking to acquire, had 15 patents back in the 80s. And since 2000, they never applied for patent at all, or never got their trademarks registered. That shows a prospective buyer or somebody you would want to do business with that you lost your focus when it comes to intellectual property. You used to protect your patents, but now today you don't. And that shows that perhaps the culture has changed against the IP. Another thing to consider is, are you strategically filing in international jurisdictions? You may think of the US as a big market, but let's say you're selling products or you want to bring your technologies to Europe or Asia. You should always look where there's a business opportunity and make sure in those countries you file your intellectual property. Make sure your trademark that you want to use for a new product, it may be okay to use in the US because it's available. You did a trademark search and you find out that using a particular trademark in the US is fine, but then that trademark may not be fine when it comes to going to Europe or Asia. Think big, think where potential markets are in the future, where you may be able to bring a product more outside the US. And international jurisdictions have different rules and regulations when it comes to protecting IP. There's certain deadlines. The US, for example, gives you a 1-year grace period to file your patent application once you disclose your product. But in other foreign countries, once you disclose, that's it. You cannot file a patent application. So you have to know the rules of other jurisdictions in protecting your IP. And then finally, that Yair mentioned, are you taking advantage of R&D tax credits and other tax incentives? When it comes to patents, for instance, or new product development, new processes, there's work done, there's engineers are hired, patents are filed, and those are all things that you can apply for an R&D tax credit. Usually if you have a patent that issued, you can easily show the IRS that for us to apply for a patent, obviously we did the research, we invested some money, we hired some engineers, and therefore usually it's straightforward that obviously you're entitled to an R&D tax credit. Next slide. And that's it for my presentation. Thank you, everyone.
All righty. Thank you all for joining us today. We've got 2 questions in the chat, and then I guess we can open up to everyone else. The first question is for Yair. Second question is for George. First question is, survey studies and research related to management or marketing functions. What if we are a marketing agency working internally on our own processes and have to show have the documentation to show this?
Right. So that's a great question. So where we find marketing firms can qualify for the research credit is if they're developing any kind of internal use software to drive the marketing function. That's where there's a possibility for an R&D tax credit. Otherwise, there really is none. I mean, surveys for the sake of surveys are not qualifying. It's really the development of software to drive the marketing function that can qualify in marketing companies.
Okay.
Marketing to drive the marketing function and to drive the business per se would not qualify. But again, the extent you're developing tools to enable you to do that or defining specifications to enable you to do that, that could qualify. That effort, those monies could potentially qualify. Does that help? Does that answer is there a follow-up?
I wasn't the asker.
Okay.
So,
but yeah, that's the gist of it in relation to marketing companies. And we do work with some advertising and marketing companies, but again, there's usually some element of software development going on in the background or heavy data analytics, things like that.
Well, so on the topic of data analytics, is data analytics for the sake of growing a business, does that qualify as research?
Right, so you're walking that gray line again. The answer is, again, if you're linked in or connected to some kind of software development effort, data analytics in Excel for the sake of growing the business would not qualify. Is not supposed to qualify.
But building a dashboard in Excel would qualify?
Right, so to the extent that you're starting to develop a tool, you're getting closer on that spectrum to qualifying for the research credit. Now we've developed a tool in Excel. So I could tell you the largest consulting firm I've ever worked with was when I was at Deloitte. I did a project for Booz Allen Hamilton, and they had developed internal use software to help their clients do data analytics. And this was 15 years ago, data analytics and drive the business through an internal software development effort and data analytics. This was pretty cutting edge at the time, and Booz Allen was able to get an R&D credit for the work they had done around that effort.
Now, how about if you hire an agency or a contractor or a Booz Allen to build a tool for you? So do you get credit? Do they get credit? Do you both get credit?
That's a great question. That's an excellent question. It comes down to rights and risks in the contracts for the development effort. In other words, if your company has the rights to the development effort and the risk to the development effort, then those QREs, those qualifying research expenditures, are yours. If not, they belong to the developing company.
Okay, but the developing company, let's assume that they have to deliver something. So,
right.
So they've got to come to you with something at the end of the day. And if these expenses don't work, unless you're like hiring them by the hour.
Do you pay them anyway? So what's the scenario? In other words, are you going to pay them regardless of whether it works or not? Those are the things we look at, right? So, and if it's a time and materials contract and you say to them, hey, Joe, keep developing. I don't care if it takes you 1,000 hours, I'm going to pay you. Then they have, they don't have any risk, right? So it comes
Right.
down to who has the ownership, the IP and the patent that George was talking about, who owns the intellectual property rights, and who has the risk to the development effort. And we review
Mhm.
contracts to make those determinations.
Got it. All right,
Great
let's,
question. That's a and Garrison, I answered that quickly, but that really is a complex area in and of itself.
uh-huh. Oh, maybe a topic for in the future webinar.
That could certainly be its own standalone webinar. Yeah.
Okay, so next question I believe is for George. And then we got another one for George in the chat. All right, it's always interesting to see or hear what seems to be a breach or break of copyright. What are the exceptions to use of others' property, i.e. notes or words of a song, words of anything quoted or stated, visual likeness, etc. Also sampling in a song. And I'll just add in one thing that we're kind of dealing with at Imperial Advisory along the lines of this question, the likeness. If we find a picture somewhere, we change that picture in some way or do something to it. How does that impact all this? Who owns what?
Right, that's a good question. We see that more and more as people take copyrighted material, say this artwork, and they want to use it for their logo, or they want to change it a bit, and then say they created a new piece of work. You have to when it comes to that, there's what's called derivative work. So copyright will protect derivative works. For example, if it's a song and you create a play or a theatrical production around that song, that could be considered a derivative work of somebody else's work, and now you're adapting it to another medium. So you have to be careful of that. It's always good to obtain a permission from the copyright owner or work out an agreement. But if it's like a part of a song or a jingle, that could still be copyright infringement. It doesn't matter how big or small the use is. Unless it's used like what we call fair use. For example, if it's for educational purposes, sometimes you can argue it's a non-commercial use. If it's somebody who's using it for a school project and falls under education, or somebody's using it for some non-for-profit promotion. But it's always a good idea not to get into that gray area, to ask for permission from the copyright owner and make sure what you're using, if it's copyrighted, the best advice is don't use copyrighted work unless you have permission, even if it's a small sampling. You don't want to find yourself in a copyright infringement lawsuit. Generally, if you are on the losing side, they could be thousands of dollars of damages based on statutory damages. So it's preset in the law, and don't take the chance. I mean, I have a client recently wanted to use an image of himself as Aquaman. I said, don't use the same image of Aquaman that's already that's part of the movie. Make your own design, your own interpretation of an Aquaman, not somebody that already created something and it's in the movie, it's copyrighted, it's owned by a production company. That's the best advice, is not to use others' work unless you obtain some permission if you really want to. And if you're using stock photos from a marketing agency, they usually have licenses to these stock photos. Always ask the question, do you have a license? Can we use this photo? Sometimes getting a license is really, really cheap for a stock photo, but if you find yourself in a copyright infringement lawsuit, it could be thousands of dollars in damages for something that could have been a license for probably a few $100, if less.
Thank you. Next question for George as well. Please clarify the idea of an IP holding for an entity.
That's a good question. That's more of a tax issue, but maybe I can chime in as well after I make a few comments. When it comes to IP, it could be universal. You can have IP patents based in Europe, European trademarks, maybe Asian patents. You may be able to have an international entity be the owner of those IP assets. Depends on the type of corporation you are. Generally, if you're multinational, we hear some large companies have Irish IP holding companies. And then anything they license and the money that comes in goes into the Irish entity, and the tax bracket may be less than if that money was coming into the US. It's probably not available for everyone, especially if you're a startup, but obviously if you're a larger company doing business international, you should maybe consider if you can do that. And I'm not sure if Yair has any experience with IP holding companies.
Very little, George. I mean, nothing to really add beyond what you mentioned. I remember looking at patent boxes and the issue of where is it optimal to hold the IP. I know that's a big issue, but again, we come into that discussion very tangentially, not really a focus of ours.
All right, thank you. We've got one final question, and then at least one of our speakers had to be on something at noon. So we'll wind down, and then afterwards, hopefully, Ariel will send out a copy of the slides, and people need a copy of the video, we can send that as well. All right, final question is, what were the copyright expirations mentioned?
Yeah, so for something that you create as the author, it's 120 years. Excuse me, the author's life plus 70 years is the life of a copyright that ownership. If you're the author, say you create a song, it's your life plus 70 years. So it's a long time that you own that copyright, or your heirs own the right to your work. And then if it's done for a business, it's 95 years from the date of first publication, or 120 years from the date of creation. 95 years from the date of creation, 120 years if it's done for a business, let's say work for hire. So again, it's a long time. So if you're a business and you're hiring somebody to work for hire project, you have 95 years from the date of first publication that your copyright can term, and 120 years if again you work for hire. And if you go back to that slide, you'll see 120 years and 95 years for work for hire for business related copyrights. So it's a long time. If you create a jingle, work of art, it lasts a long time. And if you're the author, again, your lifetime plus 70 years. And those are based on statute, and they keep changing. So as Mickey Mouse comes to expire, copyright for Mickey Mouse, Disney lobbies Congress and it's extended. So they keep changing, and they last longer and longer.
Thank you. I actually have one final question that I guess since I'm leading this, I can break my own rule. George, you talked about people at a company developing things, and sometimes someone you didn't expect to develop something ends up developing. When do you have to get these contracts in place? If that happens, is it too late already? Like, let's say someone at your marketing agency develops a tool. Do they have to sign it over to you, the employer, or they could say, no, I developed it, now it's mine?
It's a good idea to have an employee handbook, or in the contract, the employee contract, whoever is you're hiring, that anything they create or come up with during working hours, you're using your resources, let's say coming up with something for your business that you own that product or process. So it's always good to have that in place. But generally, if you don't, and somebody creates a software product and they will hire you to be a marketing professional, you can still make a good claim that you're entitled to that program, because let's say they did it during company time and you paid them for that work and they were there working on that project. So there's not so much wiggle room. They can argue that they own it, but contract is always best to make sure everybody understands their rights and who the owners are, and everything is signed and dated and understood, rather than trying to interpret facts later in court of what happened. And they can say, I did some of this work at home, I did it on weekends, it wasn't all done at the office. It can create issues. So it's always good to have contracts in place for anybody that you think can create, is potentially somebody that can add, let's say they come up with a marketing plan and you want that to be a trade secret of your company or the strategy, or come up with a potential customer list and you want that to be a trade secret. It should be understood that those are IP assets that they're creating that the company will own. And it's not something that they can just take and walk out with, even though they created it while you were paying them.
Got it. Thank you. All righty. Everyone, thank you all for joining us. Thank you, George and Yair, for an incredible presentation. And thank you, Ariel, for setting everything up. And again, we're going to send out the slides. If you have any further questions, you can reach out George or Yair or myself. If I can help, I'd be happy to do so. And looking forward to seeing you all next time. In 2 weeks from
Thank
today,
you.
we have...
Thank you, Gershon.
Thank you.
You're welcome. In 2 weeks from today, we have a webinar on working from home, a minefield for work from home, a minefield for employers. So hope to see some of you back then. Thank you all.
Thanks.